Welcome to Speechless. We're live from SPNN in St. Paul, Minnesota. We're glad to have you here. Now we're just about 3 blocks from where about 260 babies were ripped apart from their mother's wombs. And it was interesting in that aspect because I was at an event last night. Human Life Alliance was having their annual banquet, and they send out millions of information about abortion, about pro-life issues to junior high, high school, and college students. It's having a great effect. And I was at this banquet, you know, not one dime was paid for by the taxpayers. And yet you in Minnesota are forced to pay for those dollars. So this is people on their own, sending their message, changing minds, changing lives, getting the truth out about abortion. And in a couple months, we'll have somebody from Human Life Alliance on the show. They have fantastic material. So if you can go to their website, just Google Human Life Alliance and you'll find some great information. So, but also, you know, about life and about having children, having families. I've been covering the lawsuits and the issues with child protection services overstepping their bounds, and finally they're being held accountable. Dwight Mitchell's been on the show a number of times, and he's back again, but we also have a couple more guests where we're going to dig into the press conference and the court case that took place yesterday at federal court, district court, and also, you know, if you saw your newspaper, this is the St. Paul Star Tribune. You know, it was right there in the Star Tribune, an article about the court hearing. And a lot of inaccuracies in this. I just couldn't believe it when I read it. I go, whoa, they didn't get this right. You know, what do they say about if you don't read the news, you're uninformed, and if you read it, you're misinformed? I think that applies in this case. So anyway, have a whole bunch of people here, and kind of, we'll just let you introduce yourselves, and we'll start with Dwight.
Sure.
So,
Hello, Tim, how are you?
Good.
Dwight Mitchell from Family Preservation Foundation. I'm the founder of the organization and also of the parental rights group, Stop CPS from Legally Kidnapping Children.
And the parental rights group was the one that was in part of this, was it class action?
That's correct. That's
Okay.
a program under the foundation's name.
Okay. And then Erick Cardle.
Yeah, I'm Erick Cardle, and I'm the Chief Counsel for the Family Preservation Foundation and Stop Child Protection Services from Legally Kidnapping, and I'm glad to be here.
Good to have you here. And you argued the case. Yeah.
That's right, I argued the
yesterday.
case yesterday.
You did a very good job, in my opinion.
Thank you.
So, and Mel Walsh.
Hi, Mr. McKinley. Thank you for having me on. I don't know exactly what my role is. Apparently, I'm going to be one of the supervising attorneys. One of the attorneys is going to help Family Preservation Foundation with its goals and add in my litigation expertise, experience, see what we can do.
Okay, great. So, my understanding is you've had some experience with tribal issues or custody or...
Well, I'm Native American myself.
Okay.
And so I've had I've handled a couple different cases with Child Protective Services satisfactorily with Native American children. In particular, I'm thinking of the Prairie Island Native American community down there, and they are very protective of their rights. They're very protective of Native American children that find themselves brought into the system, seized into the system, so to speak, and they're very protective of their rights under federal ICWA law and Minnesota law to ensure that those children receive proper care and attention from the tribal communities, and that their parents get the proper care and attention, that they really work together. At least in my experience with the Prairie Island community, they do not terminate parental rights, and so they work with those parents as long and through whatever issues they have to get them to keep that family whole, to keep that family part of the tribe and protect those children. But it's a gross experience, a much different experience that I've had when dealing with CHIPs in the counties, where they are statutorily obligated to provide services to reunify families, but often you will find, I'll accuse them with bad faith. Yeah, you'll find bad faith on the part of Child Protective Services and their workers. You'll find that they don't work towards reunifying the families. They put up impossible obstacles and they manipulate circumstances to use those situations against the parents when it comes time for litigation, which is ultimately all that a parent, sometimes that's all the parent has to protect themselves is to go to the mats, to go to trial. And but there's big stakes.
Well, I think that's very interesting, because why does Prairie Island have this system in place? Probably because there was a problem, and then they see they needed to do something about it.
I don't want to speculate on the basis. I know the two of the tribal attorneys down there. I've known them for 15 years, and they're both excellent professionals, excellent legal minds, and they really hold the Native interests. They hold them very in high regard, high esteem, high importance. I mean, that's their job, number one, but they're also coming from a Native American background, number two, and so they have, and again, I can't speculate, but I'm seeing the effect on family. I mean, I'm sure at some point we'll get into some of the disparity here in the statistics for Native American children being brought into the Child Protective Services system versus white children in the state of Minnesota. I think was it 17% times more
Right,
likely,
17 to 1.
17.1 times more likely to be brought in and brought into the system and to receive care or to receive supervision and regulatory services. And so, I don't know why it is like that, but I know that preservation of tribal heritage is very important, and so I would think that would be a very compelling motivation behind that.
But not all tribes are that way.
I don't know. I don't have
Okay.
a lot of experience in other
Okay.
tribes. I wanted to meet with a couple of different friends of mine who have worked in the tribal organizations around the state, and hopefully I'll have additional information for you maybe the next time we meet.
Yeah, right.
That's one of the things I've gotten into is that I've called all of the tribes, and so I'm trying to schedule meetings with the tribal councils. Looking at statistics, when I found out that there was a 70 to 1 disparity taking place, and I looked at the number of Native Americans that were being removed, when I learned that Minnesota was number 1 out of the 50 states in the removal of Native American children, that's when I contacted Mel, and I just said, we need to try and do something about this. I said, Red Lake is a closed reservation, meaning they do everything themselves. Minnesota has no effect, meaning the Native Americans in Red Lake are not put into the Minnesota Child Protection Services. So there are 6 tribes that form, one master tribe. And so a lot of children from the Minnesota area, Native Americans, are being pulled in. And so that's one of the things that Mel is going to help us look at and try and address.
Would you say that they're being targeted, versus, you hear how bad it is for the counties with Child Protection Services, but do you think there's this?
Well, it's gone
the tribal
up.
community is being more targeted?
When you look at the numbers, and I actually do have a slide that we can look at later on. I actually made slides of the Minnesota out-of-home placement, so you can actually see the statistics. People hear us talking about it, but I thought if they had a visual, representation, they would really, sort of understand. When I talk about numbers, I tell everyone, this is on the Minnesota website. They only have 10 years on the website, but I did a 15-year look back, and they have consistently taken over 3,000 African Americans and over 3,000 Native Americans consistently for the last 10 years. It's actually gone up in the last 2 years as it relates to Native Americans and African Americans being removed. And I can't just say it was just them. I mean, low income Caucasians are being removed also. I mean, it's gone up across the board. But we're still sitting here saying although they're taking more people uniformly across the board, there's still this disparity. of 17 to 1 with Native Americans, 4.8 to 1 to mixed race. And so that's trickery also. When I say trickery, when you look at the page 10 of the out-of-home placement, it says that it's 4.8 to 1, 59% are African American and Caucasian, 54% are Native American and Caucasian. I'm like, well, wait a minute. If you have 1A African American, according to U.S. standards, you're African American, you know? And so if you take the 1,500 and slide it up under the African American column, well, that bumps it over 4,500 people. And if you do the same thing to Native Americans, take the other half, the 54%, and slide that 1,200 across, it takes them both up. So, I'm sitting here saying, well, they've created their own category to skew the numbers so people don't realize just how many African Americans and Native Americans they're taking. Because at any other time, they're like, well, 2 or more races. Well, when did that start? I mean, every African American is 2 or more races.
Right.
My last name is Mitchell. That's Scottish. So
I thought so.
Yeah, I think that one of the causes of the racial disparity is explained by Dwight's case. The case is both about physical abuse and neglect standards. And so cases where a parent neglects a child or physically abuses a child. And what we're talking about is the standards that the department uses, the Department of Human Services, the Minnesota agency, doesn't require for seizure of a child a substantial harm to be showed. So where there's a substantial harm to be showed, we agree there's child abuse. Those are the cases we're not complaining about. The cases we're complaining about are where there isn't a substantial harm to the child, but they grab the child anyway. The statutory standards are so low that they can grab the child for basically any reason. A parent's bedside manners, we proved in one case. The parent's manners at the hospital, which we proved in another case. The parent's ordinary corporal punishment, as in Dwight's case. So why do you get the racial disparity in these sort of situations? That is, if you have an explanation where you have an unconstitutional standard being used by the department, and then you have some cultural difference, that would explain the racial disparity. So here, in the University of Chicago General Survey, which has been taken since 1987, every year they ask the question to different people, and then they associate the answers by race. That minorities answer the question at a greater rate. Does a child who's been very naughty deserve a good hard spanking? And basically, like African Americans are 11% higher on answering that question affirmatively than whites, including Hispanics. So, okay, so if they use a constitutional standard, boom, we've taken care of 11% of the problem, or whatever it is. And the point is that when the government violates the Constitution in a consistent way, then you can identify that'll hurt African Americans, that hurts American Indians, well, then they should even more quickly fix it. And every year they put out this report, oh, we're terrible, mea culpa, there are racial disparities. Well, then fix your unconstitutional standards that mitigate the racial disparity. I mean, it's so obvious. And what this basically shows is the establishment doesn't really care about people. They'll report on racial disparities, and then Dwight raises this issue, well, you're using unconstitutional standards that are creating racial disparities. Well, at least let's fix the obviously illegal things causing racial disparity. And they say, no, Dwight, you're a bad person. Right. Erick, you're a rabble-rouser. This isn't an association of plaintiffs, it's something else. When there were authentic victims in that crowd before the courthouse, every other person was a direct victim. Usually actually every other person was a mother who had lost a child. That was a legitimate victims group.
Right.
It was horrific. I mean, the people in that audience were suffering trauma from losing children recently. Right. I could barely hold it together just mixing with those people. I was like basically crying.
Yeah.
What I found so
Well,
interesting.
we have video of that. But I was behind the camera crying too. But great. What were you going to say?
No, one of the things I find so interesting is that, they say that our association doesn't have standing, but I'm like, well, if you look at the NAACP and ACLU, they were all victims. The NAACP, their whole background was based upon, the African Americans being victims, and they've taken so many cases to court, and no one's ever said, well, you're victims, you're zeros, you don't count, you can't bring a case, you have no standing.
Yeah, the hubris, they just as a Tim, I know you've been around a while and you've observed these things. But it's the institutional arrogance and the hubris. I mean, they go into federal court, the state agency, and they say, this association, they're zeros. So they have no standing. We don't have to listen to their complaints. And I thought that was just so outrageous. I moved back to Minnesota to be with here because Minnesota's a nice place, and that wasn't nice.
No, well, this standing issue, of course, always is one of the first things that gets brought up. But why in the world did they even attempt it? You know, that's what was getting at me. Of course, I see attorneys doing that and defendants and whatever, prosecutors, you know, doing things just because it's there and it pushes things out. But I just couldn't believe that they even were saying all these people didn't count.
Well, Dwight and I talked about that today, and we had a real heart-to-heart conversation. It's very disturbing because you assume that that department's my department. Right. And I think they've got in a habit of thought, the department, into thinking that they're at the top and the child protection services involved families are losers.
Right.
And this is just too much of a existential threat. It's like, well, wait a minute. The losers are saying that we're doing something wrong. That's not correct to our worldview. The losers are always losers. And so the point of the losers banding together in a group to criticize the department, no, they can't do that.
Well,
but they're self-imposed losers. I mean, you know, the agency is the one that does all the reporting. So what most people don't realize is that count that you see, that 15,004 children, well, that's all of their reporting. That's purely based on allegations. I've been trying for weeks to say, tell me what the outcome is after you go to trial. I mean, you know, what is the outcome? I can't get that. I was told last week, I received a letter saying, well, we don't carry that information. I'm like, how can you not carry it when you bring the children into foster care? They said, well, you're gonna have to go to the judiciary and now have to file a Freedom of Information Act to the judiciary to try and get this information. And I'm just like, okay, you know, but you're saying that I'm a loser. Did the judge say that? I'm gonna take my case, for example. You know, the first thing that came out of the
well, they tried to make you look like a loser in that thing. Right. I mean, and false information too.
Hey, when you
Yeah,
not,
you should
not
cover-
even,
you should
not even
cover.
talking about Trump, but we're talking about false news. Fake news. I'm like, you had a judicial ruling on my case. There was no, the judge heard it, the judge saw all the evidence, and he ruled, and he spoke to it. For you to come in and bring in allegations, well, the police officer said this. I'm like, right, the police officer told that to the judge saw the evidence, and the judge made a ruling. And the judge's ruling had nothing to do with what they were trying to say or what they were trying to portray. You know, and so I found it fascinating because if you look at what Judge Spicer said, and I actually, made a slide of that.
Judge Spicer.
Yes,
Sorry.
Richard Spicer. Well, Richard
He's
Spicer.
on my wall of fame for bad judges, but anyway.
Well, he's on mine for good judges.
Yeah, that's how it goes.
That's how trial lawyers work too. And so your last result is what
Right.
there was.
Yeah.
Well, I mean, one of the things he said, which was really interesting, is that when he did my opinion, and so he said, well, the record should reflect that these kind of cases are interesting because what is reasonable for one parent may not be reasonable for another. There are gray areas. Having the motion to grant a felony in this case made me feel bad for Mr. Mitchell because, of course, I had him in CHIPS and he was very compliant. No prior records, nothing wrong. I can't say that I agree with the manner of his treatment, but different parents have different philosophies. He may not agree with the way I treat my children. He says, I do think based upon the pictures, it was somewhat criminal based upon this statute of malicious punishment. That means anything that's less than substantial bodily harm is criminal in Minnesota. So he's even saying it somewhat. He's not saying, you're definitely criminal, you're definitely abusing. He didn't say that. He said somewhat in nature. But I don't think it's the kind of thing we should beat the crowd up, Mr. Mitchell. I think he knows what's going on here. I think he understands. He's always been very compliant, at least in my court, and I've had him there. Based upon these factors, the court does not feel that a misdemeanor would be appropriate. So he took the gross misdemeanor, dropped it down to a misdemeanor. He stayed all other fines. He fined me $100,
Okay.
and told me, Mr. Mitchell, just don't spank the kids in Minnesota. It's we don't do it. And so,
Which who knows that? Who knows that you don't spank kids in Minnesota?
Well, but that's the central issue in Dwight's case, is that because the statute lacks a substantial harm component, so that the government can seize your child even if you're not causing harm to the child. Think about that. And then the point is, can a parent do an ordinary touching in protecting a child or disciplining the child? And so the part of the case that explains why the standing position of the state defendant is absurd is that these parents are asking the court to ask how they can conduct themselves without having their children seized. That's a fair question.
It's very fair.
So
Well, I
can't
mean,
keep-
what is
wouldn't
the
any
law?
parent want to know that?
Right.
Right. So what's the code of parental conduct?
Right.
And so can I spank my child? Can I seize my child and pull him out of a street that has cars passing through it? This is the problem, because the Minnesota statute, and Mel can speak to this, Minnesota's CHIPS definition incorporates the elements of assault and malicious punishment of a child without incorporating the defense, lawful use of force as parental discipline.
Sure.
And so any unwanted touching a parent of a child, like I said, protecting the child or disciplining the child can be the basis for a CHIPS petition.
Well, and there are a lot of laws criminal laws, that say, well, but it's not criminal if you're doing something else, protecting yourself or, whatever. So there's affirmative defenses.
But not in the CHIPS petition.
Which
And
is,
so Mal, you know about the lawful use of defense available in criminal proceedings. What would a proceeding be without that defense?
Because Mel's a former prosecutor, so that's why
okay.
he's done both sides.
Yeah. Say the question again, Eric?
Well, just the point
If
that,
there was- if there's no ability
in the
to-
CHIPS petition, they incorporate the elements of assault, incorporate the elements of malicious punishment.
Yeah.
But they don't include the lawful use of force defense.
Correct.
And so in the CHIPS petition, they just say, well, there's unwanted touching, there was malicious punishment, even though it was an order of spanking or it was a matter of protecting the child in some way. I mean, how do you even approach that? Because it's so different if you have a defense or not.
Yeah, well, if you have the affirmative defense of, say, self-defense, and you've brought forth sufficient evidence to assert it to a jury, then it's the state's burden, right? The state always has the burden of proving guilt, whether or not it's a criminal matter or whether or not it's the child is in need of protection or parental rights should be terminated. If you bring enough evidence, you have a affirmative defense, then it's up to the state to disprove that affirmative defense by the same level, the same standard of proof.
Really?
So, yeah, so if I'm, somebody pulls out a gun and I pull out my gun, or he points it at me and I shoot him first,
Yeah.
right? And there's evidence that he had a gun, he was pointing my way, the state has to prove that my counter use of force was not reasonable to protect my life or the life of another. And they have to prove that by proof beyond a reasonable doubt. So it's not just that I killed him, but that my use of self-defense wasn't reasonable by proof beyond a reasonable doubt. When that's not available in child protective service proceedings. So you're already dealing with a lower standard. It's clear and convincing evidence. Whether or not the child's in need of protective services, clear and convincing evidence. Whether or not the parental rights should be terminated. So it's already a lower standard, which is concerning when you're dealing with something as fundamental as parental rights.
Because the U.S. case law is that parental rights are very high, not at the highest level, but next to it.
Well, what I couldn't understand, it's funny you should say that, is that, and Mel can speak to this, they offered me an alpha plea, which in essence, I'm pleading innocent. I'm pleading guilty, but I'm maintaining my innocence. And I was doing that, because I needed this case to be over so I could go to the CHIPS case and get my kids back.
Right.
So I'm like, if I'm pleading innocent here, if I'm maintaining my innocence, meaning I'm like, I did not abuse my children, but I'm trying to close this down so I could go get my
Right.
children from the CHIPS side.
Right.
I was having a hard time understanding why they were saying, well, but you pled guilty. I'm like, no, I didn't. I maintained my innocence, and I went over here to get my children.
Yeah. Alfred pleas are, they're one of those, what would it be? Kind of a mythical creation. It essentially it allows a person to enter a plea of guilty while maintaining their innocence, essentially saying, Judge, this prosecution has this evidence that we agree would be admissible at trial, so there's no issues with this evidence coming in at trial. And if this evidence was introduced at trial and a jury heard it, it may very well be that a jury would find this evidence meets the standard of proof by proof beyond a reasonable doubt. However, I'm not admitting guilt. I'm not admitting that I caused this substantial harm or even less than substantial harm against my child, rather than I was disciplining him appropriately. But it could very well be that a jury would find that no, that you have violated the law. So an Alford plea is, it allows, I don't know, I guess I could pull up the case law on it, but it allows the defendant to say, this is the evidence that's coming in at trial. It would meet that standard of proof beyond a reasonable doubt. And then you can go forward with a guilty plea without admitting guilt.
So you have all that legal definition, but as a person sitting in that situation, like Dwight, I've been in that type of situation, and I'm going, okay, we can go to trial here, and I got this thing to do tomorrow, but if I do this Alford plea, $100, $50, whatever,
done.
I'm out the door, we can move on with life, and that's what I'm thinking. I'm not thinking, they don't even have enough evidence against me. But I can walk out of the door for $50.
You're not just thinking that. You're thinking, I've got a charge here with a very zealous prosecutor who thinks that I can't spank my child without going to jail, and they want to put me in jail for 365 days, right? Because it's a gross misdemeanor. That's what the penalty is, 365 days in jail and a $3,000 fine. I'm going to have to pay $10,000 to $20,000 for a criminal defense attorney, sit in front of a jury of 6 people that I don't know. I'm an African-American individual down in Dakota County, where it's not always comfortable to be an African-American individual in Dakota County in front of a jury that's typically a jury comprised of white individuals from the rural area. Don't get me wrong, I used to live in Hastings. I loved the town, loved living there. It was great, and I love the people I worked with. But it's not a comfortable place to be, or to be in a position of having these peers in the community judge you. So you don't feel that you're in a fair situation to begin with. You don't see your face or your color represented very broadly in the area. You don't see your color or your face represented very broadly in the population that's judging you. You have an overzealous prosecution that has no comprehension of the disciplinary traditions in your family, much less an African-American family, or holds your family or your African-American families in such disrepute that they believe that it's all criminal to punish your children in that way, and they want to put you away from jail for a year. You got another kid at home that relies upon you, or 2 kids that rely upon you. You're already in the middle of proceedings to try and get those children back. That's a very, very scary place to be in.
Very scary.
And to have the power of the government bearing down upon you with the venom dripping from their teeth and the expectation they're going to throw your ass in jail, pardon my language, for a year and get as much time as they can. And all you've got between you and the bars is one black robe sitting up there on the bench who doesn't really feel like they don't really care what's going on. They're just calling pitches or they're calling strikes and balls. And that's not a good place to be whatsoever.
What was so interesting in my situation is what Mel said perfectly described where I was at. And my sole thought, and I told Judge Spicer, and if someone reviews the transcripts, I'm like, I need this to be over so I can get my children. They won't, work on the chip side, until the criminal side is completed. And so I said, I need this to be over quickly. And so it was Judge Spicer who offered me the Alford plea from the bench. So, that's like a unicorn. This is a man, no, because they don't. I mean, most of them like, I'm in jail. We all see it on TV, what happens. But, I sat here with this overzealous prosecutor, trying to throw me in jail. And Judge Spicer looked at everything, looked at the evidence, police reports, spoke to people, and made a decision. He says, I'm going to stop this. This is wrong. This man, who's had, no criminal record, never been in trouble with the law. He spanked his son, and now we're trying to put him in jail. Or the prosecutor's trying to put me in jail. So he stopped the whole proceeding. So we're sitting here saying, well, if I was this demon who deserved to be locked up, and they lock us up for a lot less, I can steal a pack of chewing gum. I'm in jail.
I agree too.
You know? So you sit here and you're like, well, why would he do that? Why would he tell everyone, I'm stopping this. I'm giving this to Mr. Mitchell. Here's $100. I gave you my opinion. I saw all the evidence. Somewhat quasi. I don't agree with it, but it's not the big thing that everyone is trying to make it out to be. And so this was adjudicated. So you sit here and you have all of these these people saying, oh, but you pled guilty. I was like, well, you didn't read. And I said, you didn't read what the judge's opinion was or why he made his decision.
Well, and that's what the Star Tribune did. They came out and gave misinformation about what took place.
Yeah, and that's a non sequitur. And remember, principally, so it's out of sequence here that the criminal proceeding led to the resolution led to the civil proceeding,
Right.
and that's where Mr. Mitchell was abused because this $100 incident led to him being separated from his one son for 5 months, his other son 22 months, for something that a judge said was a $100 incident. And so if you'd imagine Mr. Mitchell going through that and then battling his way and eventually winning his back, and then we bring a lawsuit that this would never happen again to anyone. We want to know if we can do ordinary spankings. And the government's response to our claim that their statutes don't have the substantial harm component, and so people are wondering if they can spank or do some sort of benign neglect with their children. And then their response is, Dwight admitted guilt. That's a non sequitur. That doesn't make any sense. And then you look at Dwight, you were showing me earlier, that they spent like a day, the Department of Human Services, doing a one paragraph response to our lawsuit. They must have had the lawyers preparing it. And they did everything in their statement except address the point. Why don't your statutes require substantial harm? Because if they did, then you would avoid all these unnecessary out-of-home placements. And so, what are the people of Minnesota getting? I mean, why would you want legal kidnappings? I mean, they're saying it's like the Affordable Care Act. It was explained to us after the promise wasn't kept, the premiums would go down, that the increased premiums were a feature of the Affordable Care Act, right? And so one of the features of our child protection services is we take your children and put them in foster care for no reason. And then they try to convince us, no, this is good. Right. That's every day now in the papers. Right. This is good. We're good. We want to legally kidnap these kids. No.
It's acceptable. It's the norm.
Right, it's the norm. Well, yeah, and so because we do it, it's good. Yeah. And there's so many instances where the department has shown its character. Right. And so it should cause someone concern the Department of Human Services is taking this position because it reflects badly on everyone in the Department of Human Services. Everyone that works there, everyone that contracts with them. So what kind of people are these? Right. I mean, and what I found in these cases is that whistleblowers are incredibly valuable. And we started having the whistleblowers contact us, and there's so many people working for the Child Protection Service agencies, the counties, who know these things are going on, but they want to keep their jobs so they won't talk publicly.
People inside the system.
Right, and so your program is so important because if there are people in the counties who are witnessing these types of activities, they should contact us and we'll provide protection for them so they can come out.
Right.
One point I wanted to make that Eric mentioned yesterday that I think was lost on a lot of people in his oral argument is he said the state of Minnesota isn't serious about corporal punishment at all because it's legally authorized to use corporal punishment in private schools in the state of Minnesota. So it's okay for a stranger to spank my child. But the parent, as a parent, I can't spank my child. And when you spoke to that, I don't think a lot of people actually really grasp that. They're like, wait a minute, so it's legal for a complete stranger to spank someone's child, but their own parent cannot?
It was the first time they heard it. And you have to process it. Right. That doesn't make sense.
Yeah, the other thing, the U.S. Supreme Court has found that it's constitutional for public schools to use corporal punishment. And recently there was a case I read in the newspaper in Missouri some kids had been naughty, and the choice was, 1 hour of detention or 2 paddles, and they chose the 2 paddles, which I think is wise because you can do something with the rest of your time, right?
Exactly. You know how many people execute their sentence? A lot of people do, because it's over and I'm out.
Right.
No
right.
probation, no parole, whatever, I'm gone. So we got some video. So Dallas, the first video after post-hearing. No. Post-rally. SP.
Was the
Why you get that together?
Okay.
We're here today at the
No, that's not it.
federal courthouse in Minneapolis
That's not it,
to hear our
Dallas.
case.
Come back here. We'll get it.
Was it here?
It
You
should,
said Paul in
it
Minneapolis.
should be one of the longer ones. Anyway, okay, we're gonna have to go on. Another thing that happened in that hearing, let me know when you get it.
Thank you
Okay.
everyone for coming. We had a very well thought out, well presented oral
That's it.
argument today. We thank all the parents for coming down to show their support for the changes that we're trying to enact in Minnesota. Erick presented a wonderful argument for our side as it relates to the unconstitutionality that we're trying to address and change for all the parents of Minnesota. I think he made compelling arguments on why evidence needs to be presented up front before children are unnecessarily removed from the home, and I look forward to Judge Wright's decision, hopefully in our favor. To that end, I will let Erick explain a little bit more about the detail that transpired in court today. And thank you all the parents for coming out to support what we're trying to do. And we hope to affect change for all of Minnesota. Thank you.
My name is Erick Curdle, and I represented the association and these association members. And speaking on behalf of the association, we're furious. The state of Minnesota, the Attorney General's office, the Department of Human Services took the position that these people are zeros. Each of you, you're zeros. You can't bring your claims in federal court. You can't challenge the unconstitutional standards. What the hell is going on with this state agency? These people are wailing. They're crying about losing their children permanently or temporarily. What's wrong with you? What's wrong with the Department of Human Services that you're doing this to these people? You're grabbing their kids without any constitutional basis and you're keeping them, some of them permanently. This state agency better wake up. Other states are waking up. Lots of other states are waking up. Deep blue states, Oregon, Hawaii, Massachusetts. These are deep blue states understanding that single mothers get to keep their kids unless there's child abuse. None of this safety and morals and health. That's what the state of Minnesota, they want to grab your kids based on safety, health, and morals. No more. From now on, it's got to be reasonable suspicion of child abuse. The agency's overreaching is horrific, but the fact that these parents have come forward and said it's got to stop, and then the agency's treating them like zeros, that their complaints don't mean anything, is off the rocker. Minnesotans are better people than this, and they deserve a better state agency than they have. This state agency is just wrong. I was almost in tears this morning driving to this courthouse, and a female veteran called me up, and she said, I lost my kid at the hospital when I gave birth because I complained about anxiety. And I've had 2 psychological exams, and I'm fine. And so this case is about correcting a state agency that's gone rogue. It's lawless, it's violating the Constitution, and now we know that it's knowingly doing so. So this hearing was very important, but believe me, this association, this is the first step. If they're going to dismiss this case, guess what comes next? Another case. If they're going to dismiss another case, and another case, and another case. And I know that lawyers in the courtroom tend to make these things boring, right? It was kind of a little, everyone's going to say it was a little bit boring, but the point is that it doesn't matter how many lawyers you have, it doesn't matter how good the judge is, if the statutes on the top are messed up, not requiring a reasonable suspicion of child abuse, substantial harm to the child, you're going to lose, and you're going to lose badly. We don't care if you have a government lawyer. I've told many of you these standards are so low, I can't help you. I can't go into court and win because the standard's so low. And so now it's identified. It's a little issue, right? It's a little issue. These statutes should say not that they can seize your child for the health and safety of the child. It should say they can seize your child if there's reasonable suspicion of child abuse. They're regulating parental manners. They're regulating bedside manners. They can't regulate manners. They can only seize your child if there's been child abuse. That's it. And so we narrow that down. So all the child abuse cases, all right, fine. But these cases we're talking about, there wasn't any child abuse. So if there isn't any child abuse, then there shouldn't be any seizure of the children. We're really excited. I can't tell you how excited I am about you people and your claims. And I can't tell you how offended I am. I can't tell you how offended I am. And I apologize to you because I'm a Minnesotan. I apologize that my department, it's my Department of Human Services that is treating you like zeros, right? I apologize to each of you that my Department of Human Services is treating each of you like a zero, like your complaints don't matter. You don't have standing to come to federal court and say, fix it. They're saying you can't even say that. That has to stop because this is, after all, Minnesota. And when Minnesotans recognize that our government has a shortcoming, then we expect our government to fix it. And we're going to fix it, and Dwight's leading the show. Thanks, Dwight.
Thank you, Eric. Thank you to all the parents that come out. Our organization has grown to almost 5,000 members in 120 days. We're going to continue to grow strong, and we're going to branch out, and we're going to fix Minnesota. Right?
All right, that was a great rally. You know, and I wish people could have seen what was being said in that courtroom, because it was appalling to me what was taking place and what the other side was implying and trying to do. So I would love to have cameras in the courtroom.
Mudslinging when there was no argument. They couldn't put up an argument, so they had to like mudsling.
Right. Well, it's just,
the scene point on, the reason why we're here is Dwight. I mean,
Right.
Dwight has shown this Leadership, which we've seen in other groups in Minnesota. Andy Seelig, Minnesota Voters Alliance,
Right.
Greg Wurtzel on free speech issues, others. But Dwight, in this subject area, even by what he's done up to this point, is inspiring people all over Minnesota to do great
all
things.
over the nation,
All over the
too.
nation, do great things.
people were there from New York and Iowa.
Yeah, and so we have something really special in Dwight's leadership, and he's demonstrating what we can do in Minnesota to have a better government. And so everyone tells us that, oh, you've got to run an agency to be important. No, you can criticize an agency and be important. And Dwight's showing that that's possible. And Minnesota is going to be so much better off because of Dwight's contributions.
Definitely. Now, one part in the case, you were talking about federal decisions made for other states, and Judge Wilhelmina Wright said, but this is Minnesota. And it's kind of like wanted you to leave it on Minnesota and not bring in all these other cases that actually, case law that affect Minnesota because of how they were dealt elsewhere. What was going on there?
Well, no, she was just telling me to get to my work. It was a good question. It was a good point. She didn't want me to argue by analogy. And as a result, we just came back to the same two fundamental points.
Okay.
And that is that the state was arguing that Dwight and me are messed up on the law, but the fact is, on August 10, 2017, the U.S. Court of Appeals panel, James Loken, who happens to be a local judge on the 8th Circuit, wrote a decision saying that our position was well-established law, basically saying it's well-established that it's an unconstitutional seizure of a child if there isn't a reasonable suspicion of child abuse. And then the companion case is a case called Alsager, again, the U.S. Court of Appeals for the 8th Circuit, is saying that for a reasonable suspicion of child abuse, you need substantial harm. So she was basically saying, well, don't talk about other states, what do you got? And then we got everything that a trial lawyer would want. A circuit opinion,
Right.
binding precedent on the U.S. District Court.
Right.
And then the question is, why did the state show up? And so the way that I grew up in Minnesota, I grew up in a small town, was when you're wrong, you just admit you're wrong. And this whole idea that these institutions can't admit they're wrong is foreign to Minnesota. I mean, the Child Protection Services agencies should be shut down based on what we know about their character based on this lawsuit. I mean, what kind of an agency allows legal kidnappings and doesn't change its course of conduct?
Right.
Yeah, we have to suppress this character of the agency so that something can grow and replace it.
Yeah, and the character of the agency was also brought out when I forget who they were, but for the state, arguing for the state, said that every parent gets an attorney.
Oh, my goodness.
And
Dwight can respond.
well, but I was in the audience, okay, and to me it was one of those spiritual moments where people could not help themselves. And what was happening behind you and Dwight was when that was said, 60% of that audience just went like this.
Wow.
It was a wave. It was like doing the wave, and their heads were just shaking, and it was just, you just felt it. And then just Judge Wright's eyes went to the audience, and then she dug deeper. And the county attorney, or the attorneys were just going, well, yeah, they get an attorney. And she was going, oh, public defender, finally straight out, public defender, well, they have the right for representation. Well,
They have the
everybody has a right,
opportunity.
That's right.
but it was just, and the crowd didn't want to move. It was a thing you're told to be quiet still, don't make any motions, but it was just overwhelming, like, this is a fraud. How could you say these things?
Yeah, it's interesting, the conduct of the defendant, the agency. I don't want to focus on the lawyers.
Right,
But
yeah, sure.
the agency, probably the agency says when they, about these lawyers being provided to parents in these situations, when they are, it's never done in practice, but is that they don't matter anyway because the standard's so low. So to some extent, if you're going to have unconstitutionally low standards and you accept all the racial disparity that results, and basically African Americans and American Indians get screwed. And so then, okay, well, what was the lawyer going to help? The lawyer doesn't help. I mean, Dwight had the best lawyers in town, and it doesn't matter because the standards are so low that the best lawyers in town say, you got to go along to get along. That led to 22 months.
Right.
For
Yeah.
a single ordinary spanking, and so it's outrageous. But the point is, okay, so state agency, you've been negligent, you've behaved horribly, you've ruined all these families, you continue to ruin them. But now that we've spent all this time telling you how you're screwing up and how you're causing all the racial disparity, screwing all these African Americans, American Indians, and others, well then fix it. So it's the persistence and the negligence. I mean, the people need to get outraged because they have a department that's okay with that.
In response to what's been going on, because I was going to the governor's task force on child prevention and things of that nature, they have actually ratcheted up. Instead of reversing the trend, they've taken it up 2 notches. They went from 20,000 plus cases a year to 30,000 cases a year between 2014 and 15 and 16. So you're sitting here saying, okay, you're taking 10,000 more, you're investigating 10,000 more people each year, 15 and 16. So they're sitting here saying, we're doing everything just fine.
Right, and part of that part of that, Dwight, you agree, would be
Because we're protecting more kids?
No, because they're getting more money.
Yeah, the federal funding. I thought, Dwight, you want to talk about the federal funding.
Well, it's kind of interesting because, if we look at the disparity, if we look at some of the slides, I don't know how much time we have left, but
About 9 minutes.
about 9 minutes. Not going to get to those slides, but if we actually look at the slides, what's kind of interesting is that yesterday, Eric and I were talking, and Michael Beckett, who is the associate director of North Carolina?
Yep, the North
North
Carolina Department
Carolina.
of Human Services.
He actually said, and I wish I had the quote in front of me, but he actually said that, for too long we've known that separating children from their families causes trauma, and now we're in a position that we're going to stop this. We're going to try and keep the families home, keep them together, and it fostered an environment. So we would take the children and then create an environment where the parents had to work or try and prove to social services that they're fit to be a parent. So they created this environment. And Molly McGrath, who is the director of Maryland's Department of Health and Human Services, look for her TEDx. She actually says the only time that social services make money is when they take the children away. She says there's 50 agencies across the union, and she says not one of them that are doing it correct. Marley McGrath, the TEDx from Baltimore, Maryland, it was just mind-blowing. So you have these two directors, a director and assistant director, who are saying the system is screwed up. And Minnesota's like, no, it's not. I'm like, they've already said that the only time you get money is when you take children away. So you're going to tell me these two other directors who work with the same system you do in the same federal government, the same funding, they're wrong and you're right? And so there's this shell game. There's this.
So if you have to terminate the parental rights in order to get the money, do you go after easier people, and thus that's the disparities?
Right. That's why they go after. Right.
Well, no, you're taking the suburban kids, it's a little bit more intensive because the suburban parents have money to fight back, right?
Right.
And so, of course, your statistics show the low-income people are more susceptible to this sort of thing. And but the money, you end up in Minnesota, and this is what these other state officials are saying, is that when you get the federal funds for seizing children, you shouldn't form your whole department around seizing children. And Minnesota's done that. Okay, how do we most easily get federal funds? Well, by seizing the children and having really low standards. And so the low standards have developed in the context of the federal funds. So when you're in greater Minnesota counties, it's even more obvious, because you're basically saying, well, geez, if we get a dozen more kids, we can have another county job. It's the only county department where if you get more business, you get more revenue, and then you can hire more employees. And so it's really...
That happens with traffic tickets all the time, doesn't it?
Well, Assistant Director Koppel actually said that. If you go to our website, I actually put out his memo in 2014 where he actually states that the funding that they get from the federal government helps create more jobs and helps them to do more. So he actually says bill on time, and he's talking about billing. And I put it on our website. I'm like, here's what Assistant Commissioner Koppel said. He's like, telling them, the federal funding, that's how you have your job. No federal funding, you don't pull those kids out, you don't have a job. We don't need you.
Yeah, originally I think that the attacks on Dwight for using the phrase legal kidnapping, and we even got critical comments from the media, like you're losing credibility. But the point was, once we punched through, and all these facts got out to the public through television, the internet, the TV shows like yours, then all of a sudden, all the people reading and watching, yeah, it's legal kidnapping,
right.
and now no one has a problem anymore.
Right.
Because, and so it's so funny how there's a sort of establishment edge out there, and then you plow through with the facts, and then you can call a spade for a spade. And so if anyone's watching the show, I mean, you would have to say the ultimate irony is the agency called Child Protection Services is engaging in legal kidnapping. Here's my kids at home. I have 8 kids. They refer to as, at home, they go like this. They go, Child Protection Agency. It's just fantastic, because if everyone in Minnesota would just start saying Child Protection Agency, we would culturally and politically win very quickly. And they just have to realize that when an agency acts contradictory to its nature, that then the people have to force a correction. It's like you have to go in and do a spinal implant. It's a big deal. You're not chopping off hand or something. You're taking their spine out and you're putting a new spine that's constitutional in. And it's a lot of work, but this lawsuit initiates that work, and then we'll get some legislative reforms, and we can be like North Carolina and Maryland and have 60-70% fewer out-of-home placements, the unnecessary ones. And that is success.
Right.
Yeah, I mean, and so we're going to win.
You can't spend $400,000. So they you know, and I have this memo also, and it was actually in the newspaper, and I found it just humorous that Commissioner Piper was like, we're going to put $400,000 into preventive maintenance. So, you know,
Right.
And I'm like, it was this big thing. We're going to put another $400,000. I'm like, yes, but you're getting $5 billion on the backside. Why don't you take $1 billion and put it up front? Why don't you, you know, disseminate the information? You send me a ton of flyers home from school. I get so many things home from school. Guess what? On the first day of school, have the teacher give my child a flyer, or you send me a flyer and say, here's what constitutes abuse in Minnesota. Black and white, right out there. Tell the parents, if you do this, we're going to come knocking. But no, they don't. They actually, you know, hide this. They, you know, like if you really wanted to be transparent, if you really cared about the families, if you really wanted to protect, you really wanted to stop, you would send flyers home. And guess what? You could send flyers to all the schools in Minnesota for less than $400,000, but I guarantee you they didn't do that with the $400,000.
Yeah.
You know, so these are some of the things that, you know, we're speaking about. Some people say, well, they're doing it for the money. I'm like, it's obvious. If you spend $400,000 on preventive and $5 billion on foster care and things of that nature on post, I'm like, you're not trying to fix it. And this has been consistent for 15 years. The disparity has been known for 15 years and longer. And so they actually had laws in place to prevent, you know, to try and combat disparity. At one time, the forefathers, before the current administration, they enacted the American Heritage Act in 1973 because of the disparity in the foster care system. Then they repealed it. Then they had an American Preservation Act that they repealed in 2010. So now the families, you know, not just minority, but, you know, Caucasian families, no one gets these things any longer. And so I sit here and I say, well, you're not serious. As a matter of fact, you're doing the exact opposite. And then, you know, you're saying, well, you know, why are the people calling you like, you know, demons and, you know, blah, 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 blah. And I'm like, it's obvious if you just look at the legislature, look at what they've repealed, and look at what they're doing, look at what they're spending on prevention and post, you know.
We're out of time.
Oh, really? Oh, my God.
So, right? How much time we don't? Well, we got to wrap up. So, going to cut it there. Come back. Remember, if you don't stand up for other people's liberties, who's going to stand up for yours? And good men don't do nothing. God bless. Have a great week.